Mr. Vikram Nair, Ms. Cassandra Lee, and Mr. Yip Hon Wing asked about the implications arising from the application of Malaysian law at Woodlands North Station. I think this is an important point, so let me just take some time to clarify this. First, the application of Malaysian border control laws is restricted to only the designated areas within Woodlands North Station. These designated areas will be clearly demarcated with signages as required by Clause 7 of the bill, and LTA will work closely with its Malaysian counterparts to ensure that there's clarity and there are sufficient signages, and that they're also prominently displayed and presented in our official languages. Second, I had mentioned that the application of Malaysia's border control laws in the designated areas in Woodlands North Station is for the sole purpose of empowering the Malaysian officers to conduct the necessary border clearances and security checks on travellers departing from Malaysia. Members might recall that it's because they have their border control located within Singapore, so we need to give them legal effect for them to do the work that they do to clear, so that we also have a corresponding arrangement on the Bukit Chaga site. The effect of applying these laws in the designated areas will be similar to what travellers would encounter at the usual checkpoints in Malaysia when travelling to Malaysia. So the experience is not altogether dissimilar. It is just that we put them into the checkpoint, put these powers and the framework into the checkpoint at Woodlands North Station and correspondingly on the other side of Bukit Chaga. As I mentioned earlier, the list of Malaysian laws that would apply in the designated areas is set out in paragraph 16 of the second schedule. Without these laws in place in the framework that we have proposed in this bill, in the designated areas at Woodlands North Station, Malaysian officers who operate here will have no legal backing to carry out their duties here. And then in that respect, the co-located CIQ model would not work. Third, there is no change to Singapore's territorial boundaries. Clause 8 of this bill makes this point clear. Mr. Deputy Speaker, I want to emphasize this point. Singapore law remains in effect over the entirety of Woodlands North Station, even within the designated areas. Singapore officers are available to assist travellers if needed, and if travellers encounter issues or need help in the designated areas, they should act similar to how they would anywhere else in Singapore, and when necessary, seek help from Singapore authorities. Mr. Vikram, Ms. Lee, and Mr. Yip also asked about recourse available if Malaysia's officers operating in Singapore exceed the scope of what they are allowed to do. Let me just reiterate a few points, some of which I've covered earlier. The bill sets clear limits to the powers that the Malaysian officers have when they exercise their duties in Singapore. For example, on the power to take possession of dangerous or controlled items uncovered during checks and detain individuals in connection with the above, Clause 15 provides that Malaysian pre-clearance officers transfer custody of these items or individuals to a Singapore officer as soon as is practicable. Don't forget, they are located in the same space, in the same checkpoint in both Bukit Chaga as well as in Woodlands North Station. This means that if a Malaysian officer detects such items, he is required to contact ICA officers without due delay. For ICA officers to then deal with it in accordance with our own domestic standard operating procedures and in accordance with Singapore law. Additionally, Clause 18 makes clear that Malaysian officers are not allowed to make an arrest on Singapore's territory. Second, and this also speaks to some of the questions that Mr. Yip had raised, the immunities which the bill confers on the actions of Malaysian officers are not unconditional. They are contingent on those actions being undertaken as part of their official duties in the designated areas, and actions taken outside of that or which exceed the scope of those duties would then not be protected by immunities. Finally, the Singapore Minister for Home Affairs has the power to withdraw recognition for any Malaysian pre-clearance officer at any time without giving a reason. We do this for obvious reasons. We want to have the flexibility and ability to determine on a case-by-case basis, and depending on what the facts might present at that occasion, whether we need to exercise this power. I should make clear that for completeness, we should distinguish the powers set out under the main provisions of the bill and those under the second schedule. I think there might have been some conflation, and so I thought I'll take some time to explain this. The main body of the bill is focused on what I called earlier the ordinary powers. These are the baseline powers that are necessary for the day-to-day work of conducting border clearance and security checks, basically CIQ work. These include the powers to require travelers to present their passport, refuse entry of persons or goods, and perform screening and other searches, such as body searches. These are powers that are already provided to our own officers today for routine border clearance and security checks. The second schedule, however, contains special powers, or what I call special powers in my speech earlier. These are the powers that equip officers with the legal basis to manage non-routine situations and ensure travelers' safety and security. They are also no different from the powers that IC officers already have today for managing incidents at existing checkpoints. These powers have been codified in the bilateral RTS Link supplementary agreements entered into with Malaysia. The circumstances in which these powers will be used are limited. For example, officers are allowed to use reasonable force for purposes of detaining an individual who behaves in a disorderly or threatening manner. And to, I think, Mr. Yip's point, conducting or strip or body searches without consent is strictly limited to individuals who present a danger to human life or safety. Mr. Yip asked whether Singapore officers deployed to Malaysia will be able to do their jobs effectively under adequate legal protection. The bill contains several provisions and safeguards to this effect. Let me just reiterate them. First, no Singapore officer will be deployed to Malaysia for cross-border railway duties unless the minister is satisfied that Malaysian law allows the Singapore officer to do their duty, their official duty, in Malaysia properly, under the command of their own commanding officers, and that they're conferred with the necessary powers, duties, and privileges equivalent to their counterparts in Malaysia, and that is made clear in Clause 22 of the bill. As mentioned earlier, Malaysia's legislation, which is accessible online, affords protections and immunities to our officers based in Malaysia, similar to what this bill accords to Malaysian officers based in Singapore. And I think to Mr. Dennis Tan's point about there being substantive reciprocity in powers and immunities, I will confirm to him that the answer is yes. Second, Clause 24 makes clear that every Singapore officer deployed to Malaysia in relation to cross-border railways has the same rights, powers, and immunities as they do when performing the same duties in Singapore. Third, the protections and immunities conferred on Malaysian officers in Singapore are conditional on our officers being accorded similar treatment when operating in Malaysia. Clause 44 of the bill provides for the minister to disapply any of these protections and immunities if there's a change in the level of protection and immunities afforded to our officers in Malaysia. Mr. Vikram asked about operational measures to prevent smuggling of prohibited or controlled items across the border. The co-location of CIQ facilities provides convenience for travelers, as many of my colleagues in this House has articulated. But we have worked hard to ensure that this does not come at the expense of border security. So let me just reiterate these steps. First, there will be multiple layers of checks. Under the bill, Singapore officers have the powers to conduct selective checks within the designated areas in Bukit Jaga, so we can do so in Malaysia. And this is on top of the checks that Malaysian officers would have done and conducted on all travelers before they are granted departure clearance at the Bukit Jaga station. Second, when these same travelers arrive at Woodlands North Station, they may then also be subject to further selective security checks. Third, as I mentioned in my opening speech, Singapore and Malaysia have jointly developed a comprehensive set of SOPs for the purposes of conducting border clearance and security checks in a co-located CIQ arrangement. These SOPs will ensure smooth coordination between each layer of checks and mitigate the risks of threats slipping through. And I believe earlier a member asked whether we are in contact, whether they're joint exercises. The answer is yes, they are. They are planning exercises, as well as also ground operational readiness exercises that we'll conduct, not just before the start of the operationalization of the RTS Link, but also subsequently as we continue to run the both CIQs and the link. Ms. Lee and Mr. Yip asked how Singapore officers in Malaysia would handle individuals found to be carrying items controlled or prohibited under Singapore law, such as drugs or vapes. If our officers at Bukit Jaga station detect attempts to bring in vapes or drugs, Malaysian laws would apply. the traveller in question will be handed over to the Malaysian authorities, and the case would then be handled in accordance with Malaysian law and their offence and their position on offences on drugs and non-compliant vapes. But regardless of how Malaysian law deals with such attempts, our focus is to harden our borders against such items and prevent them from coming into Singapore. And so we will do so when we have the ability to do checks both at Bukit Chaga as well as at Woodlands North Station. As Singapore officers are not granted powers of arrest when they're performing their duties in Malaysia, Ms. Lee is correct to say that our officers would need to seek assistance by leveraging existing mechanisms and channels between both countries' law enforcement agencies. This is a reciprocal arrangement. So we can't arrest in Malaysia, and the Malaysian officers can't arrest in Singapore. Should drugs be found, or in fact any other illicit items be found during our checks done in Singapore, Singapore law would then apply. And Singapore's zero-tolerance approach to drug trafficking will not change. Mr. Yip asked about deployment of officers to the other country during what paragraph 7 of the second schedule refers to as serious unplanned incidents. As I mentioned earlier, this is a contingency with the intention to provide for an expeditious but a controlled way of deploying additional manpower in appropriate cases. I understand the point that members have made about the urgency of the situation. I think Mr. Tan mentioned fires, Mr. Yip mentioned incidents, and every second counts. We agree with that. We endeavor to strike a balance between that urgency and the propriety of both officers who respond to such incidents from both sides. So, for example, during a major outage, which might cause downtime on border clearance systems, for example, it is in both countries' interest to ensure that there is additional manpower to maintain business continuity, to continue the flow and clearance, security checks, and so on, and also to minimize congestion. Such deployments should not exceed 3 days in the ordinary course, as provided for under paragraph 8 of the second schedule, unless the Malaysian government puts in a request for longer duration and the minister approves this request. Ms. Lee asked how the co-located CIQ of the RTS Link compares with co-located border control in other countries. One distinct feature of the RTS Link is where immigration clearance takes place. For the RTS Link, the traveller goes through departure and arrival clearances before embarkation. And this is similar to the experience at the Channel Tunnel, which connects the UK and France, which I think Ms. Lim also alluded to. A different approach, however, is taken for the Shenzhen-Hong Kong Express Rail Link. In that case, the traveller departing Shenzhen goes through departure and arrival clearances only upon disembarkation in Hong Kong. To return to Shenzhen, the reverse journey, he goes through departure and arrival clearances in Hong Kong before boarding the train. I wish to assure this House that the model adopted for our RTS Link is the subject of quite extensive deliberations. We looked at different models. We discussed internally with Malaysia, internally as well as bilaterally with Malaysia. Obviously, the system has got to find consensus on both sides to be able to be equally applicable on both sides for this to work. Ultimately, I want to assure the House that the aim is to provide a travel experience that is smooth and seamless, as many have articulated, but at the same time, strictly without compromising on safety and security, especially of our border controls. Mr. Vikram and Dr. Neo Kok Beng asked whether there will be security personnel on board the RTS Link trains. There are no plans to deploy our enforcement officers on board the trains, but there will be comprehensive CCTV coverage of the interior of the train cabins that will be monitored back-end in real time. The rail operator also has the option of deploying roving staff on board trains as and when they decide necessary, and they will be able to contact the Operations Control Center and provide any necessary assistance during the 5-minute journey. Few members raised questions about concurrent criminal jurisdiction and cross-border incident management. In particular, Ms. Lee, Mr. Yip, and Ms. Sylvia Lim asked about the method by which Singapore and Malaysia would determine the country with primary right to exercise jurisdiction over criminal offences on board a train in transit. The country where the train completes its journey will be accorded the primary right to exercise jurisdiction. I mentioned this earlier in my opening speech, but I thought I'll just repeat some of these points. So therefore, if a if an offence is committed on a train that is journeying from Bukit Chaga Station to Woodlands North Station, then Singapore would have the primary right. And the converse is true. Earlier, I think a member said, what happens if you break down halfway and you're towed back to your original station? Then I suppose the destination will be where you're towed back to. And in that scenario, that would be the country that has the primary jurisdiction. Should the offence be committed on the reverse journey, I think I don't need to repeat that. You understand it will be the converse of what I've just said earlier. And Malaysia would then have the primary right. However, where there's public interest for us to conduct investigations into the matter, Singapore may request for Malaysia to waive its right. We have not hard-coded what public interest might look like, because each scenario could well be different, and it depends on the context, the different circumstances on which the case arises, and the way in which we might view our interest in a particular offence or the individual concern. So we've not hard-coded that into the framework here, but there is an arrangement within the bilateral agreements, and I would say also that it is not only in the context of such an arrangement where we have co-located the CIQs that issues of public interest might arise. In fact, it arises all the time when there are cross-border incidents, and you know that we have one of the busiest cross-border land checkpoints at the Causeway, and we've been managing this with the Malaysians consistently. So there'll be no change to that. The law enforcement agencies of the country with the primary right to exercise jurisdiction will work closely with the rail operator to gather and preserve any available evidence. For what we term as live cross-border incidents, such as a train stalling on the tracks, both countries have agreed that the country assigned as incident manager would also have the primary right to exercise jurisdiction and carry out investigations. That is the method I want to emphasize that both countries have discussed and agreed on in the RTS Link supplementary agreements, and both sides have an obligation under those agreements to abide by it. There are situations where one country may well want to assert jurisdiction, but there's also a process for countries to discuss if both assess that there's public interest in prosecuting the case. As I mentioned earlier, we come across these occasions not infrequently. So as long as both sides adhere to this agreement, it is unlikely that anyone will be exposed to double prosecution for the same conduct. Ms. Lim had asked in particular why the detail of these arrangements as to jurisdiction have not been spelled out in this bill. I'd just like to remind this House that our bill applies to cross-border railways generally. It is not just limited to giving effect to the bilateral arrangements for this particular RTS link with Johor, with Bukit Chaga. And it is purpose-built to accommodate similar treaties for other cross-border railways if and when they arise. We can't foresee the precise details of those cross-border railways, whether there might be a co-location of CIQ or how the parties might take jurisdiction of the trains in a manner in which I've articulated earlier. And therefore, our approach has been to espouse the broad principles on criminal jurisdiction in the bill itself. And as I mentioned earlier, some of the specifics that relate to the RTS link in this case appear in the two schedules that I've taken members through earlier. Malaysia, which I think Ms. Lim had taken the trouble of looking up the legislation, has taken a different approach. You will see that, in fact, the Malaysian bill specifically mentions Singapore-Johor link, and it is designed specifically for this link only. And that's why they have enacted an RTS-specific legislation which codifies the specific arrangements that we have agreed to bilaterally in our agreements in their bill. So they have taken a different approach from us. Mr. Vikram, Ms. Lee, and Mr. Yip also asked how both sides would coordinate responses to major cross-border incidents and whether certain operational aspects would be addressed separately under other arrangements. Sir, I had spoken earlier of the principles of cross-border incident management that both sides have agreed to abide by. These are important principles and they help determine the country that would have overall command and control of the management of a cross-border incident and ensure that both countries' responses are coordinated and do not pose unnecessary risk to friendly forces. Both sides have also addressed other operational aspects of cross-border incident management via a comprehensive set of joint SOPs. These were developed with the rail operators' involvement so that all the relevant stakeholders around such an incident that might occur can work in tandem to respond effectively to such incidents. Operational agencies from both countries, along with the rail operator, will conduct joint exercises later this year ahead of the RTS service commencement, both to test as well as to validate the application of these SOPs. Mr. Yip had an additional question on ensuring officers' accountability during cross-border incident management. Sir, every officer has to adhere to the established procedure and limits in the exercise of the powers conferred upon them. I had taken members through earlier what these limits would look like in my opening speech as well as earlier in my reply speech. When discharging their duties, be it managing cross-border incidents or even carrying out routine duties at the CIQ zone, all officers remain under the order of their own commanding officers. And this is provided for under clauses 13, 22, 30, and 34 of the bill. Turning now to data protection, Ms. Lee asked how the provisions regarding data protection would be operationalized. As I mentioned, the bill will keep the data collected or generated by Singapore officers in Malaysia under the governance of Singapore law and provide for the immunity of our equipment and our devices in Malaysia from seizure and also from other forms of interference. Let me assure this House and all members that the stringent requirements imposed on the handling, processing and storing of data in Singapore are similarly applicable to any data or information Singapore officers in Malaysia collect or generate in the course of their work. Mr. Dennis Tan had asked whether the data that we collect when transmitted back to Singapore would be protected or secured, and he asked whether it would be air-gapped. The answer is yes, it would be. So we have a secure line that transmits that data. Ms. Lee also asked how the government would hold relevant parties accountable in the event of a data breach. Since the data is collected, transmitted, kept, and governed under Singapore law, any data breach would therefore be dealt with in accordance with Singapore law, something we are familiar with. If the incident is a result of bilateral obligations relating to data protection and inviolability of equipment not being complied with, then the government will consider all available legal and diplomatic options in accordance with the bilateral RTS Link treaties as well as the relevant international law. So I believe I've covered members' queries and questions. So let me conclude. I thank the members for underscoring the point that this bill is a key supporting pillar of the RTS Link and will bring convenience of travel to several segments of society. This bill gives effect to a very comprehensive set of arrangements that facilitate co-located CIQ clearance and undergirds jointly developed protocols for coordinated management of cross-border incidents. This will in turn help to ensure that the RTS experience for travelers is not only convenient and safe and seamless, but also safe and secure. On that note, I thank the members' support for this bill, and Mr. Deputy Speaker, I beg to move.
Are there any clarifications arising out of the Minister's response? If not, Dr. Neo, short clarification, please.
Yes, very short. Just like to ask the Minister whether what's the main reason of not having security on board? Is it because the timing is the time of the ride is very short?
It's a 5-minute journey across both ways, and with the availability of CCTV coverage and the real-time monitoring that will be done in the offices on both sides, we do not think that this will be necessary. But as I mentioned in my reply speech, there is a provision and an option to activate personnel to be on the trains if necessary, so as a precaution. But as a default, we do not propose to start with having dedicated personnel, security personnel on the trains.
Ms. Sylvia Lim, short clarification, please.
Thank you, sir. One clarification for Minister.
Yes.
This is in relation to when Singapore may have to give up its primary jurisdiction to Malaysia to investigate incidents, and particularly on Clause 39(2). As I mentioned in my speech, there are 3 conditions to be satisfied, if we were to give up primary jurisdiction, and one of them is that it must also be the case that Malaysia has no obligation to seek jurisdiction to us. So what does that mean?
Thank you. Let me explain that. In fact, I had cut it up to the same page. I thought you might ask that question. Clause 39 if the member has it with her, deals with a scenario where we take jurisdiction, Clause 39.1. So if you look at Clause 39.1, any conduct engaged in by a person, whether on board train, in a defined zone and so on, if engaged within Singapore, would constitute an offence, and it will be treated as if that person had engaged that conduct in Singapore. So Clause 39.1 is a provision that takes jurisdiction. Clause 39.2, which the member referred to, is a scenario where if a person is found, if you look at B1 and B2, where the authorities in that country, meaning Malaysia, not subject to any obligation to cede jurisdiction to Singapore authorities. Ms. Lim might remember that I had said in the RTS bilateral agreements, we've come to an arrangement bilaterally on which countries would assume primary jurisdiction. You might recall that I talked about the trains, which direction, where the nose was, and so on. And so that's the framework that determines the jurisdiction. So it is in that context that we put in a provision that talks about a reference to when they might cede jurisdiction, because otherwise they will have jurisdiction over all matters. But that framework provides for when they will cede that to Singapore, and correspondingly on our part, when we might cede that to Malaysia. So if that scenario happens, then, and not just that, but then plus the other condition, which is that criminal proceedings are then brought in that country, that means no person would, on account of these provisions, not be prosecuted. So if you, even if it appears that an incident happened within the framework of what might be Malaysia's jurisdiction, but if it's not the subject, the individual or the offence is not a subject of proceedings, then the conditions are not satisfied. So I hope this makes it quite clear.
There being no further clarifications, I'll put the question to the House. The question is that the bill be now read a second time. Those who agree say aye.
Aye.
Those who disagree say no. I think the ayes have it. The ayes have it.
Cross-border Railways Border Control Co-location Bill.
Committee stage what day?
Now, sir, I move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. Those who agree say aye.
Aye.
Those who disagree say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 75 stand part of the bill. Those who agree say aye.
Aye.
Those who disagree say no. I think the ayes have it. The ayes have it. The question is that the first to second schedules stand part of the bill. As many as are of that opinion say aye.
Aye.
Those who disagree say no. I think the ayes have it. The ayes have it. Bill to be reported. Second Minister for Home Affairs.
Mr. Deputy Speaker, I report that the bill has been considered in committee and agreed to without amendment.
Third reading what day?
Now, sir, I move that the bill be now read a third time.
The question is that the bill be now read a third time. Those who agree say aye. Those who disagree say no. I think the ayes have it. The ayes have it.